All right. Well, wonderful. Hello, everyone. I'm just going to do some introductions here and then we will get started. So, hello, I'm Liz Peetz and I'm the Vice President of Government Affairs for the Colorado Association of Realtors. Thank you so much for joining us here today. We're going to be discussing best practices in property management in this industry during what are very unique times. So a very special welcome to our keynote speakers, Zvi Rudawsky, and I hope I didn't butcher that too much, and Drew Hamrick. Zvi is the managing member of Wheelhouse Commercial Management and the CEO of Boutique Apartments. Great apartments if you've never been inside them. I know I've been in one in the past. So Mr. Rudawsky has an extensive background in real estate operations, including property management, asset management, and asset disposition. He earned the designation of CPM, Certified Property Manager, and he's a licensed real estate broker in Colorado and has held the Certified Real Estate Appraiser license. So he's a Denver native, graduate you, and we're so glad to have him with us. We also have today here with us Drew Hamrick, who is the General Counsel and Senior Vice President of Government Affairs for the Colorado Apartment Association. He has practiced landlord tenant law in Colorado for over 30 years as a partner with Jetter, Hamrick, and Sulzer. And he's the author of the Colorado Legal Handbook and Lease and several revisions to Colorado's eviction statutes. He's a graduate of the University of Denver School of Business and received his law degree also from DU. We're also just wonderful. We're so glad to have you both. Drew, I know we worked on a lot of legislation, so I'm really looking forward to both of you guys providing your expertise today. So welcome, Zvi and Drew, and we will go ahead and get started.
Hey, thank you, Liz, and thanks so much for this platform. We really appreciate an opportunity to chat with your members. Zvi, I don't know if you've got an introductory thing you want to kick off with. You know, the questions we field from a legal standpoint over here almost always start with the CARES Act, so that was where I was going to take introductory stuff if I'm starting off here. So you tell me.
You know, Drew, I'm fine with you know, if you want to start off, and I'll you know, I'll speak more to, you know, what we're seeing from an operational standpoint, and if you want to address what's going on out there from a legal standpoint, I think we could probably round it out with that. And I'm sorry, Elizabeth, my name is it's pronounced Zvi, so for.
Thank you for correcting us.
No,
we can
no
all get
problem.
it correct. Apologies.
It's a mouthful, but yeah, I'll let you start out, Drew.
Yeah, Zvi, that's one of the problems. We don't have enough vowels in your name. People are left to have to insert their own. So.
Yep, yeah, absolutely.
All right, and I won't beat this one to death because the CARES Act has been subject to a lot of conversations, but I do want to give you enough of an overview on this federally, because it touches on a lot of your property management issues, particularly as they apply to lease termination. So remember, when we talk about the CARES Act, we're talking about federal legislation, and this is where most of the big programs appear, including the Paycheck Protection Program, where under a greatly expanded definition of what a small business would be for a small business loan, you can apply for a loan for 2.5 times your monthly payroll, get 2 months of that payroll forgiven, plus some other qualifying expenses, including rent and utilities, provided that you maintain payroll levels. Lots of interesting questions on the margins of that forgiveness program and what businesses qualify. It's also where the $1,200 aid for most of your residents comes into play, those making less than $99,000. A big part of it is the greatly expanded unemployment insurance benefits. and then the EDIL loans, which is also an expanded form of small business loan. Doesn't have the forgiveness component that the Paycheck Protection Act does, but still loans under very favorable terms. But within it are two separate and distinct eviction moratoriums. And the only explanation I have, or frankly, any of the experts in Washington seem to have for the way it ended up, is that it was passed in the middle of the night and nobody knew what it said. But you've got the eviction moratorium that lives in section 423 and is tied to whether or not you as the property owner request mortgage forbearance on a federally backed mortgage. And the concept of this part of the act, frankly, I don't think most of you would find particularly that offensive. It seems to me to be fully constitutional and is not all that problematic. The law allows you on a federal mortgage to, without necessarily showing a virus-related impact, to request mortgage forbearance in 30-day increments up to a maximum of 90 days. If and only if you do that, you are then required to engage in an eviction forbearance for all your residents of that property. And again, it's not qualified based on whether they have a COVID-related impact. For the period of your forbearance, plus an additional 30 days, and you're required to give a notice in addition to the Colorado notices you'd normally give, a 30-day notice to quit. So if you request a 90-day forbearance, you give a 120-day eviction forbearance. So at least by my view of the world, all seems good with that provision. But then comes section 424. And 424 does a number of things. One, it expands the definition of covered properties. So we're no longer talking about just federally backed loans. We're talking about all properties that fit the definition of VAWA protections, violence against women, any property that receives a Section 8 voucher, say, Section 42 tax credit or LIHTC properties, a whole host of additional properties. Within our membership, our estimate is that about 43% of the market falls into that definition. For those properties, there is a moratorium regardless of the request for mortgage forbearance of 120 days from March 27th of 2020. There again is this requirement of the 30-day notice to vacate that can't be given until that 120-day moratorium expires. And that effectively makes it a 150-day moratorium. For those of you that don't have a calendar handy, that 120-day period expires July 25th of 2020. And that's really where the government overstepped their constitutional rights, because obviously that is an interference with your private contract rights. It's prohibited by the United States Constitution. Depriving you of your right to go into court to seek redress is obviously a fundamental violation of your First Amendment rights. And if and when it's ever litigated, I have very little doubt that that's exactly the way a federal court will see it. But of course, none of that's going to unfold in the timeframes covered by the mandate. So as a practical matter, it's the world in which you live. It's created a number of problems for people like Liz and I on the state front, because that 120-day overstep becomes justification and a target for some of the other mischief that has been done on a statewide basis and that is still coming in the legislative session where it starts up. And we'll get into some of those state moratoriums after I pause to see if I've given Zvi a good enough entry to jump on a best practices aspect of this. Did I lose you, Zvi?
Nope, I just was looking for the unmute button, but yeah, thank you, Drew. Uh, first off, I've got to give a plug to Colorado Apartment Association and Apartment Association of Metro Denver for really, keeping us in the apartment industry informed of the various changes. I've been in this business for quite a while, and the last 2 months, I've never seen the kind of changes that we've been experiencing as an industry. And now is the time when, we need to all kind of get together, share notes, make sure that we're doing what we ought to be doing, and from a legal standpoint, but also from a moral standpoint. So some of the things that we've been doing in our portfolio, we basically oversee about 4,200 units. Most of them are in and around the Denver metro area, although we have a portfolio of properties up in the mountains. And early on, we realized that this could have an effect on rents, and so we decided to put together a specific COVID application for all residents that were affected economically or physically by the COVID virus. And we put together an integrated application that sits on our website that integrates with our database, so we can we can track every single application and work with every single resident that's having an issue. To date, of the 4,200 units, we're working with about 500 residents on their COVID applications. But what's interesting is that represents 10% of our residents, but only 2% of our residents are on some kind of payment plan. From an operational standpoint, and Holly, if you could put on the first slide. Let's go to the next one. So what you're seeing here in front of you is, again, this is limited to our portfolio. This is a comparison of delinquencies between March, April, and May. And as you can see, March was quite a bit less, but May is tracking pretty darn close to April, which I'm a little surprised. I thought that we'd see more delinquencies in May, but I think what's happening is people are getting unemployment checks. They're getting the stimulus funds, so they're able to pay rent, and we'll see what happens next month. But I think it's vitally important to keep tracking where you're at on your rental properties. One of the things we did is we classified the properties that we manage into A, B, and C classes. And A properties are either newer properties or highly renovated properties. B properties are renovated, but maybe it was done a few years ago. And C properties are in B type locations, so suburbs that maybe have not had a full renovation. If you could switch slides, Holly. So this is where it gets super disturbing. What you're seeing is, as of yesterday, our Class A properties ran at about a 3.4% delinquency rate. Our B properties were at 6.72% delinquency rate, and the Class C properties were at a 22.85% delinquency rate. That's a huge difference, and it just speaks to the fact that the people that aren't making as much money are getting hurt even more by this. And I think as an industry, we need to recognize that, and we need to work with, with these residents, with the governmental agencies, just to try to figure out how to keep them in their housing. But we also have to look at how are we going to collect rent at some point. So it's definitely a problem. If you could switch to the next slide, Holly. Leasing activity, as you can imagine, on our portfolio has dropped quite a bit. We saw a low on leasing activity basically in the beginning of April, but when the shelter-in-place order came down, we basically stopped all physical showings, and so that affected us greatly. But we've definitely seen it spike back. Last week we saw 51. We got 51 leases. These were all done virtually, and to date this week, so from Monday through this morning, I think we're at about 40 some leases already. So we're definitely seeing that activity pick up. We're also doing limited showings, which I think is going to help a little bit on the leasing front. So there's definitely activity out there. People are looking around, but given the distance restraints, it's going to take a while to get back to normal leasing numbers. If you could switch the next slide. So our retention rates, this is interesting as well. Basically, I'm comparing April of 18, 19, and 20, and we've definitely seen the net retention go up. I think both April of 18 and 19, we're at 59% retention, and then in this last April, last month we were at about 66% retention. So understandably, people aren't moving, which is good. But at some point, once things start to lift, I think we'll see that move a little bit. And if you could switch to the next slide. Oh, that's it. Best practices are beef up your virtual showings, take good pictures, get 3D tours if you can do it, provide excellent communication to your tenants, your clients, your employees, your prospects. At this point, it's vitally important to communicate very, very well, for everybody that you are dealing with on a daily basis. That's kind of my overview. I'll switch over to Liz.
Well, Zvi, why don't you let me field a couple of the questions that have accumulated in the question and answer box. And I'm going to dodge some of these specific eviction questions until we have time to go through the state moratoriums that are in play, in addition to the CARES one that we talked about. So there's a question about just repeating those section sites in the CARES Act. That was section 4023 and 4024. And I'll save you about an hour of sorting through 800 pages. They start on page 570. So, but that's an easy act to find with a web search. So as far as the CARES Act moratorium, does it apply to individuals self-managing? Whether it's a covered property or not depends on the mortgage. So it's not a matter of whether it's self-managed or professionally managed, it's what financing mechanism is on it. If, let's, in a hypothetical, there's no loan at all, it's obviously not a covered property. That process of determining whether you're a covered property is clunky, or it can be, at least on the margins. I've heard a number of our members that have had success just calling their lending institutions. Apparently they're getting so many questions about this. The typical customer service agent has it tattooed on their left palm to answer that question. So that's an easy cheat, but if not, you'd have to refer to your own documents. And the issue on disclosures, it's as easy to take this now because I don't know that there's a place in the comments that I'd prepared that fits in well. The question I've heard come up a lot in some of our association Zoom meetings is, does a virtual showing count as material negotiations between the parties that trigger that disclosure requirement? And remember, you know, that's the magic moment that you're supposed to have a disclosure, and that usually accompanies your first face-to-face meeting. So it's most of our operators' opinion that just simply exchanging the information sufficiently for them to give a self-guided tour of a property doesn't trigger that requirement, and also that getting those disclosures with an electronic signature during this, during at least the stay and safer at home portion of this is going to satisfy the requirements of the commission. To the best of my knowledge, the commission has not come out with a specific position statement to back that up, but you know, they really showed their hand with the position that they took, in my mind, largely in conflict with the governor's order at that time, that showings were not part of what you were able to do, at least pre-closing showings. You know, it's clear that they are very persuaded by trying to avoid any face-to-face exchange of documentation or meetings there. So let me supplement the CARES Act now with what has happened at the state level on moratoriums. And Liz, is it relevant? Do these guys care about the pending state legislation codifying some of those moratoriums? Would that be off topic?
Yeah, no, I think we can get to state legislation after you guys get through the state eviction.
Okay.
I know they'd be interested to hear that since we're going back into session on May 26th.
So prior to May 1st in Executive Order 51, there was a prior executive order with a recommendation but not a mandate that landlords waive late fees for April, that they find ways to work out and amortize rent that couldn't be paid by those suffering from COVID-related financial impact, that they refrain from evicting tenants for any cause during that period of time. And as a practical matter, most state courts were either closed and refusing to have hearings, or local executives like mayors were ordering their sheriffs not to enforce court orders. So that all worked well, as Zvi pointed out in his portfolio. Rent collections were relatively normal. And throughout our membership as a whole, I won't kill you with stats, but these are a couple of easy ones. As of the 6th of April, member-wide, we had about 83% collections for April. And on May 5th, it was about 88% member collections. So May was actually better than April. And both of those were only a couple of percentage points above defining normal. Defining normal is tough because you get into seasonal variances and cyclical variances when you go back a full year, but that was the best landing place we got. So the view from 30,000 feet is no underpayment crisis, at least yet. Now, of course, that's great news for somebody that's got a fully diversified portfolio. It doesn't mean much to somebody that's got a duplex and one of their people isn't paying, and they've got a 50% delinquency rate, but so far so good on that. So it was a bit of a surprise when on April 30th, the governor announced Executive Order 51, which indicated that on a mandatory basis, late fees were waived for May, that a landlord was prohibited from filing an eviction until May 30th, that a landlord was arguably, and I'm not quite as conservative as some of the attorneys that have taken this position, but arguably prohibited from even serving a rent demand in the month of May. And then the last major piece of that was required to give written notice to each and every tenant of their protection under the CARES Act. And I'll drill back to that in some more detail in a bit. So right now, if in the state of Colorado, regardless of whether you're a covered property or not, you've got this inability to file and perhaps an inability to even give the notice that would set you up before May 30th. And we've got more delays pending at the State House that, that may be in place when that moratorium expires. Now, again, just like the moratorium on the CARES Act, none of these are based on COVID virus-related income impact. So these protections apply to people that owed money before the shutdown, people that owe it afterwards, people that are holding onto your property in bad faith and in good. It just simply applies to everyone. And it's one of the biggest problems with the executive order. Again, spreads relief to people that don't necessarily need relief. Now, I don't know if this is of interest to you, but I'll preach to you a little bit. Obviously, when the governor does that, he's not staying in his lane. He's acting like he's the head of the courts, not the head of the executive branch. And he's legislating from his executive office. It's problematic on a federal constitutional level. Again, its basic problem is it deprives you as a property owner from taking your grievances to court. And that is a clear constitutional violation in addition to defending your private rights of contract. So that might beg the question is why is someone, specifically us as the Trade Association for Apartment Owners, not suing the governor over this? And I'm here to tell you it's not because it's not a winning lawsuit. It's because it is our PR types and our lobbyist types lose their little PR and lobbyist minds at even the thought of the Colorado Apartment Association bringing a lawsuit against the governor. But secondarily, that's a very expensive proposition. And frankly, the federal courts are dealing with their own closures that make the probability of getting a temporary restraining order through the court system before the expiration of the May 30th order in the first place, highly unlikely. So it's like so much of what's going on across the country. People are making things up without a great deal of regard for the law, and it's going to take quite some time for the law to catch up with that. Zvi, are you ready to go with something else, or you want me to move on to more stuff?
You know, Drew, I think you're doing a great job, and from a legal perspective, you know, as a property manager, we're just trying to stay on top of it, and you know, things seem to be changing on a daily basis. So, yeah, carry on, Drew. I think you're doing a great job.
While we're on this eviction issue, and I won't bore you with a legislative update because Liz is a lot better at that than I am. And I didn't mean at boring you, I meant legislative updates. But there's one bill that we expect in the special session. We've hijacked a very early draft copy long before it's supposed to be out there and long before it has a bill number or anything like that. But we've got some idea about what's going to come as a proposal. Senator Finberg, who's the president of the Senate, is the identified sponsor on the draft we have. And it calls for a moratorium on foreclosures and a moratorium on evictions. And let me just go through the foreclosure side first, just because it's less clunky. On the foreclosure side, it applies to all mortgages. We're not just talking about federally backed. But to get the moratorium, it has to be requested by the debtor, and the debtor has to be suffering COVID-related income loss. On the eviction side, we've got all the same problems with the CARES Act. The tenant does not have to prove COVID-related income loss. It's a straight prohibition on either filing in the courts, executing on a court order, or giving the underlying demands for a period defined as 120 days from enactment or the end of the declared emergency, whichever comes first. My best guess on date of enactment is sometime around June 15th, which means that 120-day period expires, I believe, October 15th. I don't know when the governor might ever say the emergency is over. What we've seen thus far is the emergency just morphs from one version to the next, and I'm guessing that may be still going on in October. So I think it's that hard stop date and not the soft stop date that will be applicable. And always bear in mind that the eviction process, depending upon the county, is roughly a 2-month process. So if you start an eviction on October 15, you're not going to have possession of that property back until the middle of December. So this is effectively, I don't know what that all adds up to, 6 or 5-ish month moratorium on getting your property back. So that's the environment on the eviction side you're facing if this bill passes. Now, of course, we're going to try to narrow that down to that protection only being to virus-related impact folks, and defining the eviction as the end of the process, not the beginning, which would still allow somebody to claim a 120-day moratorium and not turn it into really a 180-day moratorium. But obviously that will have huge impacts on property managers throughout the state, and the smaller you are, the more impact it will have. The reason all this is so important to you from an operational standpoint is I'd point out 2 things to you. Many times you're in the negotiating field with your residents about what you'll give them if they're willing to consensually give you your property back. And usually what you're trading away is the remainder of the eviction process. And so you're making a decision like, well, I can save 2 weeks or perhaps a month if I take the property back, so I'm not going to give a whole lot away for that consensual return. But now when you're staring at the possibility of a 5-month delay, well, the bargaining power has changed quite a bit. So keep your eyes on the prize of a consensual termination, and it may well be worth giving away a whole lot more of your potential, say, monetary claim for the early termination of the lease or your contractual right to greater notice. You know, I'd be inclined, if I was a property manager, that if somebody gave me little or no notice, paid their rent through the time they were gone, left the property in the condition called for by the lease, and paid me each and every dollar of what they had agreed to pay me under that workout agreement, I'd be likely to write off a fairly significant balance in order to avoid the delays that we're going to see in a court of law.
All right.
All right, Zvi, are you teed up with one either from a question or your next presentation piece?
Actually, I've got a question for you, Drew. When these cases do start going back to court, what kind of delay do you think we're going to start to see? Because obviously it's been 2, maybe 3 months. That's gonna push this further down the road. Do you have any inclination on how much further that'll push these eviction cases?
Well, I think there's 2 issues. Some of you may have seen, because the tenant advocates are out there putting out all kinds of alarmist stuff about how 450,000 Coloradoans, which represents 25% of the rental population, are going to be evicted. And of course, all of us that didn't sleep on the day they taught business in business school know that's not the way things work. 25% of the state doesn't sleep in parks while 25% of the units sit empty, generating no revenue. What happens is the price of rent starts to fall. But obviously, if the moratorium is 3 months long, one would reasonably expect at least 3 times the normal number of evictions, which run about 5,000 per month in this state, to accumulate. But there will be other mischief out there depending upon when this hits. We've already seen courts doing things like saying, okay, in order to maintain safe social distancing in the courthouse, we're only going to let any given plaintiff's attorney file 10 cases at a time. Those plaintiff's attorneys might, since everybody's rent's due on the 1st, these cases tend to bunch up anyway. So you might have a law firm out there that files 200 of them at a time. So those types of delays and backlogs are likely going to clog the system to some point.
All right, it looks like you guys have got some questions, so I think you can start going through some of those.
The first one I see just in chronological order is Rob's asking about a non-renewing tenant. Can we do it now? If not, when? It depends on whether you buy this theory that under the current governor's executive order, giving a notice now is problematic. I do not, because I don't subscribe to the theory that that's initiating an eviction. But there are some out there that would say giving a notice of any kind before May 30th is a no-no under the existing executive order. But whether or not you give that notice now or wait till May 30th, of course, you've got to give the length of the notice required by your lease, which is typically either a 30 or a 60-day notice. And then whether you're going to be able to utilize that notice to get into court timely to enforce it depends on what happens with this state legislation and further extensions of the executive order. So again, Rob, if I were in your shoes, I'd think long and hard. If what you're having is a fight, if you're telling them to leave and they're saying they don't want to, I'd be trying to get to a consensual move-out date, even if it was past the date that you have the right to demand, just to avoid that eviction backlog and broken system to enforce your will.
And we've basically taken the conservative approach where we're not posting any notices at this point, although we are doing a payment due notice. It's very softly worded, basically saying, hey, you owe this much money. It's an obligation of the lease, but we don't go into any legal ramifications or, make any claims that this is a process to start eviction. That being said, we have had one eviction that was due to a safety issue, and that was actually carried out by the sheriff and was done, under a different pretense. So that's, if you feel like there's a health or a safety issue, I think you can go forward with that. But past that, we're not charging any, obviously any late fees at this point, and we're just we're taking a very close look at everything and not posting anything.
Yeah, let me jump on to the tail end of that, Zvi, because under all these moratoriums, there is an exception for criminal behavior. That's element one, that is then serious enough to represent substantial damage to the property or a risk to health and safety of you or other tenants. That's primarily a talking point for people so that, our side of the industry can't say hey, your system breaks that part of the system, but in reality, those represent far less than 1% of the overall evictions out there. So it had the effect of reducing the evictions in April from 5,000 to 10. So it gives you some idea about how many disputes center around that. But if you're in a situation where you're dealing with a, meth lab or something, you still have some legal options out there, but not for many more. I see a question about masks. So let me, I had some prepared remarks on the legal requirements for masks, and hopefully this will hit the question. And if it doesn't, we'll get into more specifics. Masks are interesting because as it currently sits, there for a while, there were some disparities between the state safer at home ordinances and a couple of the local ordinances about which businesses could operate and how they had to operate. But that's all disappeared now. And the only thing that remains now that is a substantial difference is mask wearing rules. So let's talk about the state mask wearing rules first, because they're fairly easy to describe. In the non-commercial setting, just for us as individuals, there's no requirement of mask of any type. There is, and they word it differently depending upon where you read it, but there's either a recommendation or an advisement or a strong advisement that people wear masks in public. So no mandate at all. You probably all have been sucked into some of these unpleasant, everybody wanted to be the boss of each other about whether they should or shouldn't be wearing masks, but that's precisely because there's really no legal guidance on that. Now, as to us, and remember, we're in a critical business, we are mandated to wear a mask if we routinely or continuously come within 6 feet of either customers or coworkers. So that's our standard as folks out there. The last time I checked, the Real Estate Commission hadn't made up their own mask requirements, although I wouldn't put it past them. That's kind of the way they roll from time to time. So for instance, in my office, I'm sitting in my office, I've got 10 other people working here. None of us are masked, even though we sometimes, I suppose, end up within 6 feet of each other under the theory that we do not routinely or continuously come within 6 feet of each other. Now, of course, I'm talking to you about minimal legal compliance. There's an optic component to this, and there's a discretionary component. I don't take my comments as discouragement of wearing masks. I'm just focusing on when you have to without getting in trouble. So then in some localities, the big ones being Denver and Boulder, there's a broader mask requirement. And let me just find my cheat sheet on this real quick. In Denver, for the public, there's a requirement to be masked anytime they are inside a commercial business or a retail business or in line for either. So any of your public in those localities coming into your offices, for instance, ought to be masked. I don't know that you have to become the enforcement bee for the city, but that's what the city requires of them. And as to you and your workers, you are obligated to be masked when interacting with the public. So there's no specificity there of a 6 foot minimum. I think it's likely that someone would interpret interaction to require a 6 foot distance, but it's not explicitly stated. So if you've got situations where somebody might call you interacting, but not necessarily within 6 feet, that may be one that you want to mask up for. You're obligated to be masked within common areas and hallways, and that may be applicable to some of you that are managing buildings as opposed to single family. I think there's an argument that you and your coworkers need to be masked in the common areas. You're obligated to be masked within the same room as a coworker, and again, there's not that specific 6 foot call out. And the final one, the one that's probably the most quirky, is in spaces that are visited by the public, you're obligated to be masked regardless of whether the public is present. So I'm sure what they had in mind is a McDonald's, that everybody doesn't take their mask off just because there's not a patron in there. But just the broadness of that language may cause some of you grief in your office space if you have residents, for instance, coming into a leasing office with some routine, even if they're not there. So those are your rules of engagement regarding mask. And again, at this point, the safer at home as far as what the definition of a business that can be open, how they ought to operate, what staffing levels they should have, all that is now consistent between localities and the state.
So there was one question that is, can we show a property for rentals with a renter in place? So as a policy, we are not showing any occupied units. And so what our showings look like now, and this just started on Monday when Safer in Place came into effect, is, you know, we'll do one-on-one showings, but a leasing person will show up to the property. They'll make sure that there's a good, clear pathway to the apartment. So we'll prop open any of the common area doors, prop open the door to the apartment, and the leasing person will stay outside. The person will go walk the unit, and then we'll come back out, and the leasing person will answer any questions, you know, from a 6-foot plus distance from the prospective applicant. And you know, so it's you know, we're trying to keep away from any interaction, you know, and leaving it up to kind of the prospects to walk the units on their own.
Yeah, and let me pile onto that, Zvi, because this, I don't see the question here yet, but it always comes up, at least among our members, about what about entry to the residence unit? I think that's likely going to create a masking obligation in those situations that require masking when routinely or continuously within 6 feet, because within a unit, that's very, very difficult to preserve. But I think that's one of those issues where the optics start to control, and regardless of legal mandates, I think entering your residents' homes creates that obligation just out of respect to whatever level of fearfulness they might have, in the same way that, you know, some of us aren't Jewish, but we put on yarmulkes when we go to the synagogue. You know, you don't do that because you subscribe to it or you're obligated to it. It's just go along to get along. And I think it's well within what I'd call normal industry practices to mask up when going into a residence unit for maintenance or other purposes. So I see a question here from Kristen about the notice of the CARES Act, and I meant to come back to that, so I'm glad you put it there because I wanted to talk about that. So Executive Order 51, again, one of the requirements is, and if you read the executive order conservatively, it says that every landlord has to give every tenant a notice of their protection under the CARES Act. So for the first week or so of that order, it was our position, and I think most of the attorneys that represent property management company, that covered and non-covered property should send those notices out. And what we elected is to go with the notice that just presented sections 4023 and 4024 verbatim to the tenant, because that's much safer than getting into the business of advising them as to what they mean. Now, I get there's not a lot of clarity to giving that type of notice to a tenant, but that may serve some of your purposes as well. So our notice basically said, the Governor's Executive Order 51 says you have to pay your rent, And it also says we've got to provide you of your rights under the CARES Act. Here it is. Do with that as with you what you will. But the order went on to say that the Department of Housing would promulgate a version of that notice, and they since have, as of about 1 or 2 days ago. And some very interesting things showed up in that order. One, their instructions on service very specifically said that only landlords in covered properties need to send it, and only to tenants that have protection under the CARES Act. So that's a much smaller universe of people that get notice. I wrote an email to the Department of Housing without showing our hand too much, and the basic content of that correspondence was, hey, did you get the governor's office approval to do this? And they said yes, and we had it reviewed by the AG's office. So I think we've got a paper trail that's pretty strong to back off to say that notice is only required of covered properties. And if I were a practitioner, I'd use the Department of Housing version of that notice. And actually there's two notices. They break it down into a notice for covered properties where the tenants don't have any rights, and notice for covered properties where they do. But I'd use one or two of those two notices in much the same way you use the EPA disclosure form and the real estate approved disclosure of relationships, even though you can generate a form that covers your obligations there, avoid the headache and just use the government's form.
And that's exactly what we did. In addition to that, we put the onus on our clients to tell us what kind of financing they have in place. Now, obviously, with Section 8 properties or units, we know those, but we had every owner sign an affidavit of whether it was a property that was under the CARES Act or not, and then we provided all of that to our attorneys. I think for me, it's vitally important at this point to have good counsel and make sure that they understand the nuances of what's going on right now, and then provide you with good resources. There's just too much change for us to keep up with it without having good legal counsel at this point.
Zvi, talk about one of the other questions. I'm going to try to paste this Colorado Department of Housing notification website into the chat room. One of the questions is, what's the link to that? So I'll see if I'm smart enough.
One that I wouldn't touch with a 10-foot pole is, can a health and safety eviction be for smoking? I mean, in a normal world, I wouldn't want to be the test case for that, and certainly now, I don't know that I would pursue that very, very strongly right now. I think you could post a notice and let them know that they're in violation of the rules and regulations, but I don't think I'd take it any further than that. Let me see what else we've got.
Yeah, I'll just echo what you're saying. Evicting a tenant for smoking is usually a very difficult thing anyway, and it really depends on whether your lease says no smoking or not. If it says no smoking, then you give them a demand that says you're violating your lease by smoking, stop or I'll evict you, and then you evict if they don't. If your lease doesn't say anything about smoking, well, it's not a lease violation to smoke in a private residence. But assuming it is a lease violation, you're not going to turn smoking into criminal activity at all, one, and then two, not to that heightened definition of the type of criminal activity that can still be evicted over. So smoking is something they're going to be able to get away with in this declared health crisis.
There's another question there. Any requirements to sanitize the tenant's apartment after a showing? Again, we've just elected not to show occupied units. Obviously our maintenance techs are doing work orders. we had limited during the shelter in place work orders to just emergency only, but all of our maintenance techs are going in. They are wearing PPE. They've got the masks. They've got disinfectant with them. So basically anything that they touch, before they touch it, they're required to disinfect it, and then after they touch it, they disinfect it. If they are going into a unit and somebody is, clearly sick, we're letting our techs know that they don't have to go into that particular unit. We also have a brief questionnaire for all prospective residents as well as current residents, just to kind of pre-qual them to make sure that they are not sick. We also circulate a list of units in our portfolio that we know of that are under either self-quarantine or are positive or presumptive positive. And then basically those units, we're not going into those units at all until they've been cleared by a doctor.
Okay, I've posted that link to the Department of Housing Notice of CARES Act rights as answers to a couple of these. Hopefully that shows up to everybody in the group that's interested in that.
There's a question, can an owner seek past due rents after a tenant moves out in July, even if collecting past due rents is months after? I don't see any problem with that. If basically, all of these regulations, in my opinion, have not limited your ability to collect rent. And if somebody moves out down the road and they owe you rent, then at this point, you can go after them. This has not absolved them of their obligation to pay rent, and I think that's important to note. It's increased. It's made it more difficult to enforce it right now, but I think down the road, if somebody owes you quite a bit of money, you can go after them. I don't see anything that says you couldn't.
All right, I see a couple of follow-up questions on the demand. Again, there are those that are reading Governor Polis's Executive Order 51 to prohibit demands. That's a very conservative reading of the order. But I think the best practice is, rather than giving a statutory demand, and a statutory demand basically says, pay me in 10 days or get out. And it's the or get out part of that causes heartburn. So simply modifying your rent demand to say, pay me in 10 days is clearly legal, and I think operationally necessary. Our members have found that they have much higher collection percentages when they give some type of balance due notice than when they don't give anything at all. But you don't necessarily have to utilize a statutory form and potentially incur the wrath of the or get out part of the demand. All right, and I'm sorry for the pregnant pause. Some of these questions are kind of lengthy and I'm having a hard time talking and reading.
All right, so I'll jump in on one from Brian. I've been leading showings of vacant units with the cleaning mitt to open and close doors, wipe the handrail on the way out, telling prospects no touching, works fairly well. I think that sounds good. I mean, I think as long as you're practicing social distancing, have masks on, obviously you need to keep yourself, your employees, and the prospective residents as healthy as possible, and anything you can do to do that, I think is huge. You know, the no touching is, I think that's a huge item. You know, we will disinfect vacant units after a day of showing, and before anybody moves into a turned unit, we do let it sit, and we also put a note that the unit has been disinfected. So it helps when people are moving into vacant units as well.
All right, Zvi, let me start with a topic I've been prepared for, and then maybe you can review some questions so that we're a little quicker on the uptake. This is the issue of opening amenities. And I can tell you that, one, it's lawful to open most amenities at this point. And I was a bit surprised that every time among our membership we talk about this, we don't get standing ovations over it, but rather an awful lot of worrying about whether it's still a good idea. And if I had to tell you what seems to be the most common practice out there, is people are looking to that same functionality in the private sector and saying, okay, I'll open when they can open. So if it's a gym, for instance, or fitness facility, they're saying when 24-hour fitness opens, I'll open mine. But the legal rules of engagement are different than that. Specifically, under the governor's Safer at Home order, and the best language to find that protection is the Public Health Department's order that's promulgated under that order, and it's Public Health Order number 2028. And that gets a little confusing because they number them the same way the governor numbers his executive orders, but it's the order of the Public Health Department 2028. And it says that fitness facilities and personal services that are part of a residential apartment community are exempt from these closures. So really, really strong backing to open your fitness facility, and plausible backing to open everything else as something that is a personal service as part of an apartment community. Now, you are still obligated to maintain safe social distancing of 6 feet, to engage in heightened cleaning, to prohibit gatherings of more than 10 persons. And that gathering concept gets clunky because you and I all know what a gathering is when we see it, but there's not much legal description to what it is. Obviously, 10 people going to Rocky Mountain National Park is not a gathering, but 10 people sitting in your business office likely is, and the difference is really one of the dimensions of it. But with a large enough space and people not being there for the same purpose, I could see more than 10 people in a facility that they would not be a gathering. You know, imagine a very large pool deck, for instance, that you got a group of 4, a group of 6, and a group of 3 sitting there, all 6 feet apart from each other, but 3 distinct different gatherings. I think you could probably win the argument that even though there's, if I did my math right, 13 people out there, you don't have a gathering of more than 10. But that's largely going to be facility and fact pattern specific. If you have the type of amenity that works to say, okay, everybody stay 6 feet apart, no more than 10 of you in here at a time, and we'll clean more often than we normally clean, you've got a plausible amenity opening situation there. Are you ready to roll with one of these questions, Zvi? Let me take one then. Showing a property and the person I'm showing it to won't wear a mask. Can I require them to? And that largely depends on when you're located. I don't see any grounds to require it under state law, but you could likely require it under, say, Denver or Boulder local ordinance based on that entering, I don't know that you could call it a retail or a commercial property, But certainly you've got a situation where you're likely to be within 6 feet. But if you're going to, I always encourage my clients not to go to war with their customers over things like these. So I don't know that I'd want to be in the position of being the mask boss, but if you're very, very concerned about it, there's nothing that would prohibit you from having a business policy of I just don't do business with people that don't have masks, in the same way that you have a policy that you don't do business with people that don't have cash. But I'd want that policy in writing, because you're going to leave some of those conversations with irritated people, and irritated people tend to try to make up fair housing differences of how you've treated them versus someone else. And you'd want to be very, very consistent with enforcing that policy across the board. I got another question about that link to the Department of Housing notice. It is in a couple of these answers, and I don't know what you guys see. So I'm going to type it into this very last anonymous attendee version of this question. Hopefully everybody will be able to see that.
I've answered a couple questions, so I'm not sure if they're going just to the person that asked the question, or if they're going to everybody.
Well, what I see is a box that asks me to send it privately, and I don't check it, so I think everybody sees it, but I don't know how to make this platform work to just put it out there in some other format. It doesn't give me the option to answer a question. So,
what if you put it on the chat instead?
Yeah, let me try that. That might work well better for participants. Do you have another question you can take while I try to find that?
Are gloves no longer needed during showings? I don't know that gloves were ever needed on showings. I think it's a preference. But I'm not 100% sure that they were ever required, or they are required at this point.
There are a couple legal requirements, and I didn't mention them because they come up so rarely in our business. But the local ordinances, again, this isn't on a statewide basis, they require gloves when you're in contact with a customer or when you're handing a customer goods. So in those localities, I suppose if you were a nurse taking blood pressure, or if you were behind the Chipotle counter and handing them a burrito, you've got to be gloved in that scenario. But it's hard for me to imagine in our industry too many situations that require you to touch your customer or hand them a good. Of course, for optics, again, there's nothing wrong with gloving up, but the experts on actual controlling things like asbestos and such that glove up for real. Of course, they've got very detailed protocols about how you put them on and take them off without contaminating yourself. But something to keep in mind is that gloved hands are likely to be dirtier than washed hands. So if what you're really chasing is not having a virus on your hands that you put into your own eye or that of your customers, you're likely better off ungloved. But I do see some advantages to the optics of when entering a customer's apartment to glove up, just to show you care more about the virus than they do.
I think we've covered most of the questions, if I'm looking at this correctly.
Okay, I've got one from Pat Hutchinson. Hey, Pat. If you open your clubhouse by appointment and the pool and fitness center, would you be in violation of 51? And certainly not by appointment, but you know, under Public Health Order 2028, you can go even further than that. There's no requirement it be by appointment. Those things can be opened by state public health order, provided you maintain 6-foot social distancing, gatherings of no more than 10, and engage in heightened cleaning. And that heightened cleaning concept is probably worth talking about, because there's a lot of guidance on how you should really concentrate in a workplace environment on cleaning shared items like, well, one, don't share them, but to the extent you have to, wiping down shared items between use. But largely beyond that, heightened cleaning is ill-defined, and I think any cleaning that's more than your normal cleaning can be argued to be heightened. But Lord knows, vague legal requirements like that lend themselves to disputes and answers that surprise us all. And I think that's some of the hesitation people are having about fitness centers in general, because, you know, they seem like relatively dirty places to us as laypersons. But it certainly seems to me that the requirement of, you know, here's your little box of towelettes, wipe the machine down when you're done and wipe it down before you use it, is a heightened recleaning requirement and consistent with the public health order.
So I got a question that, are you fogging all units COVID clean prior to resident moving in? We are not fogging the units. We will go through with a disinfectant. We'll wipe everything down, and we let it sit for 72 hours prior to move in. And, you know, so we're leaving it up to our cleaning staff who has the correct cleaning supplies to disinfect the unit, but we are not fogging at this point.
All right, well, while we have some downtime, and see if you chase the next question, let me talk about swimming pools a little bit, because of the amenities, I think that may be the most clunky one to try to figure out whether it's safe to open or not. Public pools, those pools out there that aren't in complex, are clearly closed by state order. So in order to get around that, you'd have to argue that that pool is a personal service included in an apartment community, just like a fitness center, and that would be your exception. Now, of course, the fact that it doesn't specifically call out pools makes one a little more nervous. But something that's helpful is the CDC has published a link on their site that basically says there's no evidence that the virus is transmitted in treating water, and that subject to local and state requirements, that it's okay to open pools, provided that you maintain safe social distancing and engage in heightened cleaning. And they get fairly specific about what heightened cleaning looks like on a pool deck and a swimming pool. The thing that struck me was the need to wipe down things like deck chairs between usage. But again, I think you can delegate that task to your users with signage saying, you know, wipe down your chair before and after use. So you've got some things to hang your hat on swimming pools, but I certainly get that that's going to be a more scrutinized decision, and that's going to seem further out there as far as pushing the envelope to the average resident with a chip on their shoulder. And I've certainly heard some practitioners that are going to open their decks for sunbathing, but not actually pull the cover off the pool and allow for swimming. But in my mind, I think a lot of that turns on what the demographics of your pool look like. If you've got a, small pool area, small number of users, people are sunbathing 6 feet apart and occasionally taking a dip to cool off, that's a much different scenario than 26-year-old playing Marco Polo and climbing all over each other. And you may have the kind of community you can't maintain that social distancing, so you don't even want to try. I do think, up until now, we've enjoyed the position of being able to tell our residents, hey, the amenities are closed because of the law. It's not a violation of our contract that we're not giving you all the things that we promised you. And I think those days are going away fast as there's arguable positions that these amenities can't open. And I know if I lived in one of these big complexes where the units weren't that nice, but we had a $3 million smoking common area to work in the business center and sun and barbecue and all that, I'd be an angry customer if those things weren't open the minute that they legally could open.
Drew, there's a question. I think I know the answer, but I'd defer to you on this. But can a landlord ask their tenant to move out when the lease is on a month-to-month, and he plans to put the property on the market? Landlord gave the tenant 45-day notice.
Well, it falls back into that same issue we've kind of beat to death, which is you can ask, they can move, but you've got no mechanism to make them move when they don't do what you ask them to do. So it really depends on factually what happens when you ask. If what the resident says gets stuffed, there's a coronavirus emergency out there and it's far too dangerous for me to breathe the air outside my apartment, you're not going to find a court of law that's going to back up your request until at least May 30th and possibly longer than that. So you may have to find a suitable carrot rather than the stick that you normally have to enforce your will in a contract dispute. Let me see if I'm getting to these questions about the 24-hour versus 72-hour notice. I'm not sure that it still sits out there on the CDC site because one of the things they do is update their positions on things, and their old positions go away as if they never existed. But for the longest time, what they were telling us is that a piece of real property was clean and virus-free if it had been sat vacant for 72 hours. So 72 hours has become kind of well, I don't know whatever else is going on, but I do know that I can prove it sat for 72 hours. So I'm just going to incorporate that into my turnover so I don't have to worry too much about micromanaging the cleaning. So I do think it's a good idea to follow that policy of not putting people in and out of a unit right on top of each other. Whether that alone is enough to give you any legal relief from an obligation for heightened cleaning, I can't tell you as of today. It wouldn't surprise me that it's moved.
So on that next question, yeah, we are letting it sit prior to doing cleaning and maintenance. In addition, once it has been turned and cleaned, we're letting it sit. So yeah, we're being super conservative.
And Sean, I'm going to have to dodge your question. It's an interesting one on a furnished house. What's your obligation to the furniture? Not enough of our members are in the business of exchanging furnished property that it's ever come up, and I haven't researched it. So it'd be just speculation if I piped in on that.
And Bev has asked, I'm more worried about when to send in my staff, maintenance and cleaning, after tenant moves out. Absolutely. I mean, I think I've got the same worry, and with occupied work orders, it's the same issue. I think it's have a good policy and procedure in place. Make sure that you've got PPE for the maintenance techs. That we've got hand sanitizer. That when they walk into a unit, if they're touching anything, they disinfect it before they touch it. It's just following good, smart protocol to make sure that they're not getting sick. One of the questions we struggled with is what if a tech goes into a unit and those folks don't want to wear masks? We've basically said, hey, if they refuse to wear a mask, you don't have to go do that work order, and you can we can reschedule it for when they're not there, or they can put on a mask. So yeah, it's a difficult time right now, and especially for those guys that are out in the field, for sure.
Yeah, and let me hop onto that with some employee questions, because this may pertain to some of the folks in the group. Remember, we are a critical business. Therefore, the obligation to reduce staffing levels to 50% do not apply to us, but we're still subject to the more generalized request that we reduce in on-site work staffs as much as feasible, and allow people to work from home when possible. So I think most of our members have found that through the combination of the different shifts that already exist, as well as some reallocation, that it's pretty easy to stay below what one could argue was 50% of their potential staffing anyway. But as to those that work at home, there's an advisement to people that are at risk that they stay at home. There's not a requirement that people at risk stay at home. So if you got an employee that's in that at-risk category, and I'll circle back about what that category is in a second, but you can't force them to stay at home, but you also can't force them to come to work. So that at-risk category includes some that you might not have suspected. Obviously, people with compromised immune systems, and people with whatever other group of made-up disabilities they might come up with fit that category, but also pregnant women and those over 65. So, we're now starting to see the issues of employers wanting their employees to come back to work, and employees that have figured out that not working in this current environment is less stressful and more profitable than working. So the question sometimes comes up of, when do I dig in my heels? Because it's difficult to sometimes distinguish between somebody that's got a legitimate virus-related fear and somebody that's just a malingerer. But if you're contemplating going to war with a pregnant woman or someone over 65 on these issues, tread very, very lightly and get an employment attorney involved, because trying to compel them to come to work could be very, very dangerous.
There's a question about cash for keys. I assume that's a resident who wants to drop off the keys and you give them a check. I assume that's what that means. Yeah, I mean, if it's that versus having a unit occupied that's not paying, I'd much rather have a unit that we can go in, turn, and potentially release down the road.
Yeah, it's a great option, and even greater in this current environment of the broken eviction system. But remember all the pitfalls of cash for keys. That slang sometimes imply that you ought to have less in your hand than you need in your hand when you give away the cash. I mean, you need an empty unit as well as keys, because if you're hoodwinked and you depart with the cash, you'll be right in the same situation we've talked about before, where you've got no enforcement mechanism. There's no exception of, Judge, I want the guy to move because he just stole $2,000 from me, than just a standardized non-payment of rent. But if you get a situation where, and these are tough to structure because half the time the tenant needs your cash in order to move and get you that empty unit. So I understand what you're up against. But until you have an empty unit and keys in your hand, you don't have what you're chasing in order to part with that cash. And I'd be remiss not to add, I'm sure everybody in this call knows it, but those types of agreements you absolutely, positively want in writing, because those are the kinds of agreements that either people have a different expectation on and there's a legitimate difference of opinion, or someone is just plain not telling the truth about, and proving what you have and don't have there could be critical.
There's a question of if a tenant tells us they have COVID, can we ask for documentation? So what if somebody says, hey, I'm under quarantine, you know, we take their word for it. We put it on the list of units that techs should not go into. We are asking for financial documentation if they fill out a COVID application and are asking for a rent deferral or a payment plan. You know, we do want to see that they are truly affected, you know, economically by COVID. So that's part of our qualification. Now we're not being super diligent about it, but we are, you know, asking for some verification that they have been affected economically.
Yeah, on the income side of that, because the world's your oyster there. If someone's asking you for a consensual concession because of a loss of income, you're perfectly free to say, well, prove that to me. And what most of our members are adopting a policy of is either a copy of an unemployment insurance application or an employer-related letter evidencing the termination, suspension, deferral, furlough, whatever they're calling it. But I sure would not get down the path of asking them to prove their medical condition. Oddly, there's some of you are probably familiar with the reasonable accommodation to a disability claims. And normally one would think that COVID would not qualify as a disability because of its lack of permanence. You know, if you're home because you're recovering from knee surgery, that's not a disability, that's convalescence. If you're home because you have the flu, that's not a disability, that's illness. And the difference between both those things and a disability is permanence. Now, on the fringes, when you talk about a long-term illness or a long-term convalescence, you can see how that starts to look like a disability. And so there's lots of cases saying absolute permanence is not required. But Colorado Civil Rights Division has already come out with their statement that they view COVID as a disability. How they got there, other than perhaps they slept on the day they taught disability in law school, I don't know. But, you know, a fair housing fight is, you don't have an opportunity unless you're willing to take it all the way to federal court and spend $250,000 to win what the legal issue is. It's rather what the administrative enforced issue is, and that's the $10,000 fight you have down at Colorado Civil Rights Division. So I'd be really careful about pushing the envelope with anybody that says, I've got the virus and I need this concession or that.
Well, thank you guys so much for joining us today. I know we're like a couple minutes over 3 o'clock. I want to be respectful to everybody's time, but I can't thank you guys both enough, Zvi and Drew, for being on the line with us today and giving us your expertise. As you can see, we had tons of questions to keep you occupied.